fantastic pleasure and privilege to follow Justice Breyer and to be in the presence of Justice O'Connor, who's made such a sustained and deep commitment to these issues. In her remarks this morning, Justice O'Connor noted that there is some variety in how well are addressing the question of ensuring judicial independence, and she mentioned two states that face particular challenges, Wisconsin and West Virginia. And in our discussion today, I think we'll touch on both of those states and try to learn some lessons from what they're going through and what sort of solutions we might discover. Our first speaker until recently was a justice on the Wisconsin Supreme Court, Louis Butler. We saw some ads before the lunch break, and I want to tell you about an ad that played a role in Justice Butler's defeat. It was a nasty, expensive, and which is to say rather typical judicial election campaign. And the ad that really struck me, although there were many ads, and there were bad ads on both sides, but here's the one that I thought was very hard to believe was part of the civil discourse of American democracy. It starts with a picture of Justice Butler in judicial robes, and then shows next to him one Reuben Lee Mitchell, also African-American, and Reuben Lee Mitchell had raped an 11-year-old girl. And here's the text of the ad. Butler found a loophole. Mitchell went on to molest another child. Can Wisconsin families feel safe with Louis Butler on the Supreme Court? Now, the ads that we saw before were bad on their face, but many of them were misleading. Let me tell you how misleading this ad was. Justice Butler had represented, as a lawyer, 20 years before this defendant. He persuaded two appeals courts that the defendant's trial had been flawed, but the Wisconsin Supreme Court said that was harmless error, and the defendant served out his full term, after which he went on to commit another crime. So let me read you that text again. I suppose in some sense it's accurate. Butler found a loophole. You know, as a lawyer, years before, he ensured that his client received a fair trial. And although an excellent lawyer and the first public defender in the history of Wisconsin, I think, to argue a case in the U.S. Supreme Court, he didn't win this case. His client served out his term. And yet the ad says, Butler found a loophole. Mitchell went on to molest another child. Can Wisconsin families feel safe with Louis Butler on the Supreme Court? Let me tell you a tiny bit about Justice Butler, and then we will hear what it's like to try to be a judge in this sort of climate. He was born in Chicago, earned a bachelor's degree from Lawrence University in 1973, a law degree from the University of Wisconsin Law School in 1977, served as assistant state public defender from 79 to 92, and then as a judge from 92 to 2002 on the Municipal Circuit Court. In 2002, elected to the Milwaukee County Circuit Court, and then appointed to the Wisconsin Supreme Court in 2004, where he served until this August, I guess. Justice Butler.
Thank you, Adam. First of all, I do want to thank Justice O'Connor, who I did have the privilege of arguing once in front of a number of years ago, back in 1989, and fortunately for me, she does not remember that argument. It was a right to appeal case, and she wasn't too thrilled with the point I was trying to make during the case. I'd also like to thank Justice Breyer, who's been an outspoken proponent of judicial independence. I have quoted him many times in speeches throughout our state during my term on the Wisconsin Supreme Court, and I'd like to thank you for all you're doing as well. And I have to admit that this is a difficult topic to address. One of the concerns that I have, and one of the reasons why I have declined to talk to media in my own state about this topic, is because it's too important to trivialize. And I don't want to be in the situation where you have people saying, well, you've got a justice here who lost a campaign. This is sour grapes. This is, you know, he didn't win. He's just, you know, crying in the wind. And so I've been very careful not to go around and trivialize this issue, and I've been avoiding the media. But I do think it's important to talk to national organizations, national groups, national media. And the first interview that I gave was to Adam Liptak, who did an article.
Excellent choice.
Who did an article about what happened in Wisconsin. So I think it's important to kind of put it in perspective, to just kind of give you an idea of what essentially your money is being spent for around the states in this nation. Just a brief question to the audience. How many of you have had the opportunity, I know you're busy and it's difficult to find time for light reading, but how many of you have had an opportunity to read John Grisham's The Appeal? Welcome to my world. Essentially what we had, I was appointed in 2004 following a merit selection process. I know that's an issue that's very important to Justice O'Connor. I was appointed following a merit selection, a little bit of my bio, and there were a lot of expectations when I got to the court. After all, here's a black, a former public defender, appointed by liberal in every case. That was the assumption. That's what I walked into, and I was coming onto a court that had a 5-2 conservative majority. And it was pretty much felt that I was going to be ineffective, useless, and safe. And then I got to the court as expected. I followed the rule of law and voted my conscience in cases, and all of a sudden it became a little bit more difficult to predict what the court as a whole was going to do, because you had different majorities on different cases based on the issues that were presented to the court. And what happened, quite frankly, even though the court pretty much voted consistently on most issues, there were 3 decisions in 2005. I won't bore you with the details. I'd be happy to discuss them with you later. But there were 3 liability decisions that were rendered by our court in 2005 that got special interest groups in our state outraged. And one group in particular, Wisconsin Manufacturers and Commerce, decided at that point that, okay, we've had this court for all these years. We've never had to worry about how the court voted. We get this new guy on the court, and all of a sudden we lose these 3 cases. He's got to go. Billboards went up in our state that called Wisconsin the Alabama of the North, which brought a retort from the state of Alabama that said, don't compare us. There were editorials that were flying through the Wall Street Journal, through some of the Wisconsin papers. Money was spent. There were studies that were done, and the studies were interesting that were done about the Wisconsin Supreme Court because they did not look at all of the decisions rendered by the court. The decisions that were selected were the few where the court disagreed with certain interests that were out there. Those were highlighted, and then they compared the justices' voting records and said that certain justices always voted this way, justices voted that way, whereas if you looked at all the cases, you actually found a pattern where some of us were centrists on the court, but that meant nothing. So as a result of these 3 cases that got the scrutiny of this organization, I was targeted. There were efforts to encourage individuals to run against me. The public number of individuals that declined were 7. We are aware that the organizations that were doing the recruiting efforts have privately admitted that the candidate that they ultimately found was a 13th or 14th choice. We know from talking to some of the judges who were actually recruited, who no one knows of, that the number is closer to 35. But there was a heavy recruitment effort to locate a candidate to run against me in 2008. Now, all this started in 2005, mind you, and notwithstanding the fact that there were approximately 300 decisions that I participated in as a member of the Wisconsin Supreme Court, these 3 cases generated this type of attack. But interestingly enough, no one wanted to talk about the 3 liability decisions when I had to run my election. The only thing that they talked about were decisions in the criminal area. And I'm not going to talk about the decision that Adam had referred to, the ad that Adam had referred to, because, quite frankly, that was not done by private interests and by private interest groups and by independent expenditures. That was done by my opponent. But I do want to talk about some of the ads that were run as a result of independent expenditures, because you need to know how money is being spent in these states. Essentially, we had 2 cases that I was involved with on the Wisconsin Supreme Court in the criminal area. One involved a DNA case where the evidence that the prosecution argued for conviction, the semen, blood, and hair, the semen and the hair was later, following the conviction, shown the defendant, although the closing argument was that it was the defendant's. And the blood that was found underneath the defendant's fingernails that supposedly was the victim's turned out to be paint chips. All right, wasn't blood at all. So, in effect, we had a case where the evidence was not supported by the DNA test that followed. The court ordered a new trial. There was a campaign run, advertisement run with respect to that decision. The more important case involved a case that actually was pending at the time before the United States Supreme Court, Giles versus California. And we had a case where a woman died. Shortly before she died, she wrote a letter and gave it to her neighbor and said, if anything happens to me, please give this to the police. And the letter implicated her husband. Now, every member of the court agreed, and I'm not sure how would feel about this given its most recent decisions in Giles, but every member of our court agreed that this was testimonial evidence, and therefore the confrontation clause would apply unless there was a doctrine of forfeiture by wrongdoing that would be applied that would keep the evidence out, because you're not supposed to benefit as a result of your wrongdoing as a criminal defendant. But the doctrine that was in place at the time that the Constitution was adopted, and the doctrine that was in place in the federal rules, under the federal rules and in the federal system, did not match the doctrine that our court wanted to employ. So 6-1, I was the one. The court said, we're going to adopt a broad new confrontation clause doctrine that basically says, all right, if you cause the absence of the witness, we will admit the evidence. That was the only criteria. If you cause the absence, essentially a homicide exception to the confrontation clause. And I objected and said, wait a minute, if you look at Crawford, if you look at Hammond, if you look at Davis, and we were aware that Giles was pending, the court has not gone that far, and there has to be some linkage to causing the absence for the purpose of keeping the person from testifying. So I wrote on that. 5 different campaign commercials were run on that issue. Be afraid, be very afraid. That type of message that I almost jeopardized a prosecution. Now, this was a pretrial ruling, that a prosecution by voting in this fashion. And it was of little solace that approximately 6 weeks after my election, the United States Supreme Court adopted the very position that I had written in that case, in the Jensen case, before our court. The money that was spent in our race, the public figure that's been put out there, was $2.8 million of independent expenditures against me. The public number of independent expenditures on my behalf was supposedly $2 million. We know that that number is grossly underrepresented because none of it tracks the cable money. And all of the cable expenditures, unless you have the resources and are willing to go out to the municipalities and track the cable spending one by one, you can't get at those figures. So the estimated spending in our race was somewhere in the vicinity of $6 million. It was probably closer to $10 million to essentially come in and buy a seat on the Wisconsin Supreme Court. And as I indicated, we had to, and one of the interesting things about the 2 cases, and I know we've got to move on because we've got other panelists, but the interesting thing about the 2 cases that were selected, both of the cases were pending in the circuit courts at the time. So I had an ethical responsibility to not respond. I couldn't even respond to the charges that were leveled out there. And the net result of the election, 51% to 49%. An unknown was selected with no appellate experience, very little trial experience, who had been a judge for 5 years, and he is currently sitting on the Wisconsin Supreme Court while I'm teaching at the Wisconsin Law School.
Thank you. Thomas Gottschalk has given a lot of thought and shown a lot of leadership in this area to what the corporate community might do in response to some of all of this. There's a very good paper in your materials on recusal as a possible partial solution to some of these issues. Mr. Gottschalk has returned to Kirkland and Ellis, where he'd been a litigation partner for many years before joining General Motors as Senior Vice President and General Counsel in '94. In 2001, he was elected Executive Vice President for Law and Public Policy, a post he held in his retirement from GM in 2007. He serves on many boards, including the Institute of Legal Reform of the Chamber of Commerce, Justice at Stake, and Transparency International.
Thank you very much. Again, for me also a pleasure to be here. I thank Justice O'Connor for her leadership over the years on this issue. I actually have to express some mixed feelings about being here because I think I'm, in a sense, sort of a corporate representative, even though I'm going to disclaim that I represent anybody or any view other than my own. And the other reason for some discomfort is I'm going to follow Justice O'Connor's admonition and be fairly candid about some of my views. And again, I suspect they'll be disappointing to some of you, but perhaps that will promote some further dialogue and discussion if there's time. The two questions I'll get to after just a little bit of background and perspective to have a better idea of where I'm coming from and why. This panel was asked the question, can corporations help stop the funding arms race in these judicial elections? And notwithstanding the fact, as Justice Butler has detailed for you, these elections have gotten terribly nasty, terribly expensive. Long term, you have to agree they are largely corrosive of public, said, in our court system. From my experience and being involved in this for a long time, my answer is probably not, at least not for a long while. Can it be stopped? And that's not to recognize that the vicious circle isn't there and continuing. I'd love to see a situation where we could get corporations, unions, trial lawyers, social issue interest groups, and others in a room, and perhaps something like that can be tried at a state level or a local level or something like that with some effect, some leadership. I don't think it'll happen unless the judges are in the room with them, indicating their point of view, as has been done at this conference. So I do want to cover that topic because it's the heart of this conference, I think. We recognize we have a very ugly problem out there, and we feel stymied about what we can do to address it. But then rather than leave things in a sort of total hopeless state, hopefully talk a little bit about some things that I think we all can be doing, including corporations, to mitigate some of these negative consequences of costly judicial elections. Now, just briefly, because it's not the primary topic of interest to you or for this panel, but I do think important to give a little personal perspective on this. I became interested in these issues as a young lawyer in Illinois when George Rennie Sr., then Vice Chairman of Inland Steel, actually, led an effort for many years to move Illinois from an elective to a merit-appointed system. And frankly, that was done largely out of concern over the quality of the bench in Cook County, which was primarily a patronage system from the Daley regime and didn't really constitute anything other than a reward for political service. George worked long and hard and got nowhere on that. In Michigan, I saw similar efforts. Other states, despite the efforts we've made, we seem to have very little traction on this issue of moving to a merit-appointed system. We've tried public financing. A couple states have it. It's always optional. So I don't mean to suggest we give up any more than we give up on other big problems, cancer, AIDS, and everything else. We keep working at it, and working at it, we don't give up. But I'm a realist, perhaps you think a pessimist, when I indicate that experience tells me that it's going to be very hard to change over at the root cause of the problem, which is the electoral system and what elections breed. Now, again, I don't represent any group here or even GM or my law firm, but I do think I have some perspective on the corporate community, and you heard some of it from Brad and Ken this morning. What is clear, I think, is that corporations recognize they're both plaintiff and defendant. They're frequent parties in litigation, as the second panel indicated. My take on the corporate community is that it wants courts that are predictable so they can plan their business activities with some assurance as to what the law is and will be, and that courts are efficient so that the cost of litigation does not preclude anyone from obtaining justice through the courts. And business generally, like most everyone else, wants judges who are experienced, intelligent, and impartial, and that they will reserve judgment in any given case, as Justice Breyer indicated, until both sides have been fairly heard and issue rulings based on a considered analysis of the facts presented and the applicable laws and relevant precedent. Business generally, as we heard this morning, believes in and supports the rule of law, not just in developing economies, but everywhere, including here. So, why can't corporate funding of judicial elections be stopped? And again, a little bit more perspective on why I come to my view. As to why I think from a business perspective it would be very unwise for corporations simply to abandon, I think you all refer to as unilateral disarmament, the political fight over judgeships altogether. In my perspective is on how the arms race got started. Not that that's an excuse for continuing it, but it's important in terms of the attitude I think a lot of companies have about this. And my perspective began to develop in the late 80s, certainly the 90s, when corporations were facing a few jurisdictions, often at the trial level, but even a fewer jurisdictions at the appellate levels as well, which operated as what Dickie Scruggs called magic jurisdictions. And quoting him, magic jurisdictions are where the judiciary is elected with verdict money. The trial lawyers have established relationships with judges who are elected, and so it's almost impossible to get a fair trial if you are a defendant. So this was coming from the trial bar itself, talking about the system we were facing. So we did go out and talk to various state court leaders and various organizations. What can be done about these unrepresentative but terrible jurisdictions that put a bad name on courts and a bad name on our legal system. And we were told candidly the courts felt relatively powerless. These were political problems. These were electoral systems, and we had to find a political solution. And so my view on it is that various NGOs at the state and national level, with corporate sponsors and members, have taken on this political fight with voter education, grassroots efforts, and other techniques, including legislative measures, to try to obtain what in their mind is a more balanced and impartial judiciary in certain states. But the arms race was then on. It's been met, as I said, with unions. It's not just trial lawyers and corporations, it's unions. It's everybody going into the political process because there is a lot of power inherent in the judiciary. It does make a difference who's on our court. I realized how big a problem this was in Michigan when I first got up there and saw the ads that were running even for trial courts, and we saw some of those at lunch. I was dismayed by that. And so trying to figure out how we could get at this problem has been one that's perplexing me for at least 20 years. The reason at this point that I'm pessimistic about it is that, as the Supreme Court and various opinions of members of the Supreme Court has indicated, if we're going to have elections and states choose that, then you've got to pay the price of elections. And elections are bare-knuckle fights. They're not fought with a lot of particular rules for nicety. Attack is the name of the game. And one of the reasons I'm for elected systems, among many others, is that, as Justice Breyer indicated, one of the prime functions of courts in our society is the protection of individual rights and minority rights, a very unpopular thing to do. And yet we're running popular contests for elections. That doesn't make much sense in terms of judges like Justice Butler being easy targets, sitting ducks almost, for people. So my view is that with the current state of Supreme Court precedent, and the view that more speech and unfettered speech is the essence of our democratic system. I've heard Justice Breyer on other occasions say that one answer to bad speech is more speech, and so that's sort of where we're going with this. People feel that that's essential for elections, and the second is the First Amendment, obviously, which may tolerate limits on contributions which constitute express advocacy for or against a candidate or the functional equivalent thereof, but does not permit limits on debate on issues or policy or petitioning and what we call issue advertising, which is what those ads we saw earlier today claim to be. So what we have right now is the standard set out in the Wisconsin Right to Life opinion by Chief Justice Roberts, 5-4 as I recall, indicating that the First Amendment standard must give the benefit of any doubt to protecting rather than stifling speech. So what we have is accepted doctrine that corporations can be denied any opportunity to contribute to an election campaign. That law is. But where is the line? Where is the line between what's an election campaign and what is other types of policy advocacy for which the First Amendment affords protection? So the current test is that an ad is the functional equivalent of express advocacy only if the ad is susceptible of no reasonable interpretation other than as an appeal to vote for or against a specific candidate. You can't look at implied intent under the majority opinion or intended or actual effects. Is there no reasonable interpretation of the ad other than as an appeal to vote for or against a candidate? So they've taken the language of these cases, and the election lawyers have, and to come as close to the line as they can, they have said, just be sure you don't say for or against, say call, and that takes it out of the election context. Talk about a policy issue, and we'll call it issue advertising, and corporations have a right of free speech, everybody else does, and indeed campaign contribution limits, if they apply to that type of speech, might be unconstitutional, a question I'll put to Ted at the end of my remarks. So we're clearly operating in a serious constraint here because you can't legislate or regulate this type of speech, apparently, under the Supreme Court standards. So we're faced with elections as the preferred popular will. We're faced with the rules that elections have to be relatively unfettered. And this issue advertising really can't be regulated as campaign or election speech because it partakes too much of policy advocacy, which is essential in our democracy. So that's a pretty formidable set of barriers to having effective reform in this area unless we move to systems like merit appointment or whatever. So I want to end by talking about maybe some ways of mitigating the negatives unless we can get to these different systems we're talking about. My paper deals with recusal. There's not time and it's too detailed to go into it, but there are 4 elements of the model judicial code and the judicial codes that are in effect in most states that are relevant here. One, most of them have limits on the campaign contributions that a campaign committee of a judge can accept. and they vary. There's an appendix that gives you the range of limits, but Ohio recently has adopted one that has very tight limits on this, and so there are some limits on what one can contribute directly to a campaign. We have no solicitation clauses that apply to judges. Are those constitutional? They may not be. That's up in the air still. There are some states that say judges are precluded from knowing who their donors are, so there can't be any sense of bias or partiality in favor of them. And then what I'm suggesting is that recusal is a fourth element of the judicial code that could be used to at least mitigate the negative public perceptions here by making it clear that judges don't want any part of hearing cases where large donors appear in front of them. And the interesting thing is that this was proposed 10 years ago to the ABA and adopted by Jack Martin, then a lawyer for Ford. And even though it's been in effect in the model code for 10 years, it has yet to be adopted in any state. And so that made me wonder, why is it? Did Judiciary heal yourself? You've got a provision here that you can adopt in your own judicial codes. Why hasn't it been adopted? And so the paper gets into this, but I think one of the reasons, and there's not time to get into them all, obviously, is that many of these states do have campaign contribution limits. And if they're low enough, you can argue there's no need for a recusal rule because it would be illegal or a violation of code to have a contribution above that level. But my feeling is that these codes offer an opportunity for the judiciary to make a strong statement and do everything it can that it wants no part of being tied to the virus, if you will, the disease of these campaign contributions infecting digital campaigns and eroding public confidence in terms of the fairness of the courts in reaching decisions, particularly if contributors might appear in front of them. But the problem is these contribution limits are not clear in and of themselves when they're written, and under Supreme Court law, it's not clear whether they really reach to this third-party issue advertising, and so far there's been no attempt to have them reach to this third-party issue advertising. They're sort of silent on the subject. So to wind up here, what I think I would suggest to this group as one of a few positive measures to think about is, couldn't the judicial codes be extended to what passes as issue advocacy, at least to some extent? Courts can take that on their own. Is that a violation of the Constitution? Is recusal such a harsh remedy that it's unconstitutional to have judges disqualify themselves if they know that the Wisconsin Chamber of Commerce or the Wisconsin Teachers Union is appearing before them and gave a large contribution? I think under the disqualification rules, which talk about the appearance of propriety and avoiding the sense of partiality and bias, that courts could do that on their own, even by code. It would be an interesting test. The other thing is, the Supreme Court has talked about the functional equivalent of express advocacy, but we don't know what that's going to be, and it's going to be an as-applied test developed over cases over years, a long time to wait. Why don't the states start attacking that again in their codes? And you could have a definition of what is a contribution that is more explicit and specifically says that if an ad is running during an election cycle, which encourages the listener to think favorably or unfavorably about a candidate, that ad also constitutes the sort of contribution to a campaign, expenditure on behalf of a campaign that should lead to the right of recusal by the opposing party. So I think that judges can put this in their own code. Certainly as individuals, they can adopt these rules. So adopt tighter contribution limits, adopt recusal standards, apply recusal to advertising you think is the functional equivalent of express advocacy, and let's see how the courts develop that. Third, even if it's not covered by the code, I think judges can set the example by recusing or disqualifying themselves, even if the code doesn't require it. If they know that a person who contributed or helped their campaign appears before them, they can just act on their own. And finally, even though I think money, no matter what rules you develop, will flow up to the line, corporations can do more to try to influence groups that are working on their behalf to improve the tone, as Justice Butler has indicated. I think they can support merit and hopefully that gets off the ground someday in more places. But I do think one thing they can do, and the position I've taken consistently, is that elections sort of are the low road that's been set out there now for the way we select the judges. There's a high road, too, and Justice O'Connor represents that. But I think corporations can put as much money toward the high road as they're feeling compelled to put toward the low road under these current circumstances in supporting civic education. You know, the public is not going to respond to our comments about what a great jurist this is because they wrote a reasoned opinion. They're going to go to these gut issues, which are more like typical political campaigns. The critical need is civic education, and not just of young people, but adults as well, in terms of the role of the courts and what we're looking for in terms of the quality of judges. And corporations can speak out on that, and they can help finance efforts in that regard. So at least let's have some equal contributions to both efforts here. And I think those are some of the things we can at least do immediately and keep trying to build momentum toward a better situation. Thank you.
Ted Olson is, of course, a partner at Gibson, Dunn, the former Solicitor General of the United States. I want to congratulate him for his 50th argument in the U.S. Supreme Court this coming Monday, the first argument of the new term. He has been involved in many notable cases, not least of them Bush v. Gore. And a case that particularly interests me is one where he represents the petitioner in a cert petition to the court that Justice Breyer alluded to, involving whether the Due Process Clause might indeed require recusal at some point.
Thank you, Adam, and thank you, Justice O'Connor, for everything that you've done and for including me in this. When I was asked whether I would participate in this panel, I said I'd love to do it, but I have a very strong interest as a lawyer because I'm a participant in this case, and I think the feeling was, as long as we revealed that to you, that bias that I have, it would be okay for me to describe this case that we're hoping that the Supreme Court will take. The thesis of the case is that this arms race, which no one is going to withdraw unilaterally from, isn't just corporations, and it isn't just labor unions, it isn't just trial lawyers, it's interest groups who feel that they can influence the selection of judges, because if they influence the selection of judges, they will get the judge they want. As one of my partners said once in a situation, all he wanted was a fair advantage. Now, we know that the public confidence that everybody's talking about today, and Justice Breyer talked about particularly, is, and Alan Greenspan was terrific about this too, it's public confidence, it's trust, it's faith, it's belief in the legal system. If we have that, we accept decisions that we may not personally like. We accept the rule of law if we have confidence in the individuals who guide us through the rule of law. We will not have confidence in the judicial system if we believe that judges are selected on the basis of their popularity, on their ability to, on their willingness to announce ahead of time that they will rule in a certain way and will not have that open mind that Justice Breyer was talking about, on the basis of their ability to raise funds, on the basis of their perceived favoritism to a particular side of litigants. That diminished confidence is something that undermines all of the things that we believe in, especially the people in this room. But that message has to go out much further, because there are these arms races in these states. It's a race to the bottom. It is getting worse. My thesis in this case is that there is a role for the Constitution and the Due Process Clause in determining when a judge must recuse himself from participating in a case, because that judge not be perceived by the public to be able to strike the balance fair and true. In a case that the Supreme Court decided in 1986 called Aetna versus Lavoie, a case I'm familiar with because it's one of the earlier ones I handled, the Supreme Court dealt with a case coming from Alabama in which a closely divided court involved one judge who had a particular interest in the outcome of the case because of other pending litigation. And the Supreme Court said, as we all have heard before, that no judge can be permitted to try cases where he has an interest in the outcome. Well, what is a sufficient interest to cause a judge to disqualify himself? It's never going to be a precise, clear line, but neither is the reasonable searches and seizures or due process or equal protection. None of those are clear lines in our Constitution. The Supreme Court in that case formulated one articulation which is a situation which would offer a possible temptation to the average to lead him or her not to hold the balance nice, clear, and true. Now, there are other words that can do this, but let me describe the case that we're bringing to the Supreme Court. If the court takes it, I think it will accomplish a number of things, even if we don't win. an outcome that just is inconceivable to me. This is the West Virginia case that Adam has written about, and the New York Times has editorialized about it. And I'll try to express the facts based upon the record and bias I might have about those facts. It was a fraud case against the Massey Coal Company for allegedly driving a competing coal company into bankruptcy. The jury reached a $1 verdict against the Massey Company for compensatory and punitive damages. While an appeal in that case was being prepared to the West Virginia Supreme Court, and that's the next step in West Virginia, and the court doesn't have to take the case. The court can take it or not. In 2006, Massey's, the defendant in the case, the chairman and CEO of the company, in the case, spent $3 million of his own funds, an incumbent justice by the name of Warren McGraw, in favor of another justice, Brent Benjamin, to the 5-person West Virginia Supreme Court. The $3 million that came out of this individual's pocket was more than all of the other contributions to that candidate combined, was more than 60% of the total spent for that candidate. The amount included $2,460,000 to one of these 527 organizations, which you must have faced, and the name of the organization, which was created to defeat the incumbent justice, was called this. I know you know this, but it will sound very familiar. For the Sake of Kids was the name of the 527 organization. It was formed to defeat the incumbent justice. $2,460,000 went to that that so-called 527 group. Only 4 groups in the United States spent and received more money in state elections in that year. The Republican Governors Association, the Democratic Governors Association, and the Republican and Democratic legislative advocacy groups. So that one group received more money than any other organization in the United States in state elections except for those 4. Plus, the CEO and chairman spent $507 of his own money for direct television and newspaper advertisements, plus he raised another $800,000 from other people for a total of about $3.8 million contributed to that one race. Now, it worked. The individual that he supported won as a result of one of what the newspapers called the nastiest campaigns in the nation. There was a recusal motion by the party that had won in the court below to require the justice to recuse himself, the new justice, which was denied. Then the West Virginia Supreme Court was granted. By the way, one of the ads was that the justice that was wound up being defeated, Justice McGraw, had voted to release an incarcerated child molester and permit him to work in a high school. Letting a child rapist go free to work in our schools, that's radical Supreme Court Justice Warren McGraw. Warren McGraw, too soft on crime, too dangerous for our kids. Very much, I guess, the formula spins out. And I don't know anything about these justices. I'm just reporting is in the record. Then, after the recusal motions were denied, the West Virginia Supreme Court took the case and rendered a 3-2 decision, reversing the trial court verdict, requiring a dismissal with prejudice of the case so that it would go away. And the justice, Benjamin, was one of the justices who voted in the 3-2 majority. A petition for rehearing was filed, and while the petition for rehearing was pending, photographs appeared in the newspaper with another West Virginia justice who was in that 3-2 majority, Chief Justice Maynard, who was vacationing on the Riviera with the same Mr. Blankenship who had contributed to the election that we've been talking about. On the Riviera, and I understand there were persons of the opposite sex on this. The New York Times has seen these photographs, I think, but I have not. So then there was another recusal motion. At that point, Justice Maynard stepped aside. Chief Justice Maynard stepped aside, recused himself, and then the process by which, and another justice stepped out too, the process by which replacement justices would be selected that had been in place for 28 years was set aside, and the justice who would normally have selected replacements from other courts in West Virginia was set aside, and Justice Benjamin, who had won this election, selected 2 new justices to appear on the court. So there were again recusal motions. They were denied, and then the majority ruled again to set aside the trial court $30 million or $50 million verdict. We have filed a cert petition in this case, which is presently pending the court, and Justice Breyer's disappeared, so I feel a little bit better about talking about this. It will be sometime this month. The court will decide whether to take it or not, and as you know, the court may decide we don't want to get involved in this particular case. There have been elections that have been around for years. It's going to be very hard to do a standard, develop a standard. We've explained that there are different recusal standards in different courts of the United States, but it's not the classic circuit split that invites the court to take a case. But we're hoping that the situation that we've been talking about today and this example and the other examples would be sufficiently compelling to the justices of this court to say that we need to go back and visit what we said in Aetna versus Lavoie in 1986, where there was a direct financial interest, and examine the circumstances under which the due process clause would require a justice or a judge to recuse him or herself in order for a fair trial to be had and for the perceptions of justice to be vindicated. I think that will, just taking the case, will be a very important salutary development, because if, as you all know, if the United States Supreme Court takes a case, the nation's attention will be focused on it. Is like one of those ERISA cases. This will be a case that people will pay attention to, and Adam will make sure that people pay attention to it because he's been studying it for quite a while. So that when people do pay attention to it, and there have been a variety, the Brennan Center filed an extremely helpful brief in this case, amicus brief, briefs. The press will cover it. Broadcasters will cover it. It has got all of the attributes of a novel, for heaven's sake, so that people will be seeing what has happened here in the context of what is happening elsewhere in the United States, and which is, as we've seen, a the elections of judges, the regrettable, I think almost everybody, even the participants in the process, think that this is a regrettable process. So benefit number one will be, attention will be focused on this. It might cause states and judicial codes to be developed finally to follow the ABA recommendation. That might be one outcome. State laws might be passed. Examination of the alternatives to judicial elections might be considered. So I think it would be very important in connection with what we're talking about today. Secondly, if the court decides the case in the way I hope it would decide it if it takes the case, it will be telling judges all over the United States, that you have a responsibility not just in the case of a proof of actual bias, which no one can ever prove, but you have a responsibility to the perceptions of fairness and that we've been talking about here today. You must think about that, and you must be very careful not to participate in a case if your presence in the case as a decision maker would undermine or compromise the confidence in the public in the judiciary, not just for this case, but for all cases, because it will then tell the public that judges know that they shouldn't do this, and it will improve the people's perception. And the third thing it will do is it will tell people that want to contribute $3 million or $2 million or $100,000 to a judicial election, that's not going to help you, because the more you contribute, the less likely it is that the judge that that you've been trying to elect will be able to rule on your case or on your issue, whatever it is. Now, there's a lot of unanswered questions in this area, but I think what we've had developing in this country and the importance of the confidence of the public in the independence of the judiciary will benefit by a close scrutiny of this, and however the court decides, there will be benefits achieved by the public for focusing on these issues and causing judiciaries throughout the country to think about it.
Well, we don't have much time left, but I'd love to have a question or two from the audience. But let me ask a follow-up question to Tom and to Ted. Very well briefed cert petition, lots of interesting amicus briefs. Not a notable business presence, though, and we've been talking about what companies might do in this area. I wonder if my premise is correct, and if it is, what's the reason for that?
I wasn't out seeking amicus briefs for this, so I really don't know what the experience has been.
I do think we have one or two briefs, Adam. Now, I haven't gone back, and I don't have the list in front of me. That is somewhat representative of a business group. My experience, and when I was asked to take this case, I said, look, a lot of people that I generally represent have been fighting fire with fire. They've been participating in this process. They're not going to be so happy for me to suggest that their participation in the process is going to bring about all these recusals. But I think that my answer to this is that this has got to stop, and I think that if the court takes the case, not everybody files an amicus brief in connection with the cert petition. And the court is not that excited about getting a mountain of briefs just to decide whether to take a case or not. If the court grants the case, there will be a lot of amicus briefs in this case, and I would predict that they would be from all sides of the political spectrum, and the business interests will be every bit as concerned about the things we're talking about today as other sides of the political spectrum.
Justice Butler, you heard a lot of proposals about ways in which we can use tools to try to fix the system, and recusal, of course, is one that people talk about quite a bit. Do you think they work?
Well, it depends on how far they go. Quite frankly, recusals that are limited to campaign money that is donated specifically to a candidate's campaign, if recusal is limited in that area, the net effect is you take the candidate out of the loop as far as the advertising is concerned, because most of the money, at least in our state, is being spent through 527s. In my race, I spent the most of the two candidates. I outspent my opponent 2-1. I spent $350,000 on media. We know that $4.8 million was spent on media by independents, and we suspect that somewhere between the vicinity of $6 to $10 million was spent on media by the independents. So the net result in my election is that no one heard from the candidates. People heard from the 527s. So if you have disclosure and recusal with respect to just candidate money, then the parties that are interested in getting candidates elected just won't give to the candidates. And who has an interest in these things? You've got lawyers, plaintiffs' lawyers or defense lawyers that are interested. You've got unions and teacher unions, other types of unions. You've got business groups interest in who's going to win or lose these elections. Not many other people are donating in judicial races. I mean, one of the things we joked about all the time in Wisconsin, but it's kind of a reality, is that no one cares about a judge until you're standing in front of one. And that's the reality that we're all faced with. People don't care about judicial elections, they care about political elections. They're more tuned to what's going to happen in November than what happens in a nonpartisan state like mine in April. And so our voter turnout in our state was somewhere in the vicinity of 19% in the judicial races. Now that's what we're looking at around the country, and that's why these independent expenditures are so much. So to the extent that recusal is effective, it will be includes 527 money that's spent. It will be effective if you have disclosure of 527 funds. If that's not done, quite frankly, the only thing that you do is you take the candidate out of the loop.
I agree that real consideration has to be given to extending these rules, whatever they are, contribution limits or recusal, beyond the current direct donations to a campaign. But where I differ from Justice Butler is I don't think it's going to be all that effective. And I don't want us to mislead ourselves. I think adopting recusal is important for two reasons. One, you avoid the poster child cases that Ted's taking up. And two, symbolically, it shows the court is sensitive to this issue and is stating as a matter of policy in its judicial code that it's not going to sit in cases of large contributors. I was struck, again, being fairly new to the code, the fact that we have judges disqualifying themselves for very minor stock holdings as an economic interest in the outcome of a case, and yet they're talking about 7 years of judgeship at high salaries. That's not an economic benefit that affects the judge, plus the prestige with the job, et cetera. The reason I don't think it's going to be all that effective, though, is the 527s, if you have recusal, they're not going to appear in front of that judge, if ever. It'd be once in a lifetime. So recusal is really not going to apply. So then the question is going to be, are you going to try to take recusal all the way to all the contributors to the 527, which gets into real First Amendment free speech problems, which I think are insolvable at that stage, whether it's the teachers' union, and you're going to talk about recusal with members of the teachers' union, the executives of the teachers' union, how far does this go? So I think there are a lot of practical issues. But the important thing is every place that we can to take a stand, to stand for the principle that we want courts to uphold the public confidence in their fairness and impartiality, particularly from a parent standpoint, important to do, even if it's not a panacea or comprehensive remedy. The question I have, Ted, is recusal may not be as effective, but campaign contribution limits would be effective with a 527. Do you think there's a possibility that those would be held constitutional by the Supreme Court if we had a contribution limit of $5,000 for a 527, doing some of the ads we saw today?
Well, the Supreme Court has so far upheld contribution limits as opposed to expenditure limits, and they've upheld contribution limits when there is not proof, but a perception that it is a corrupting influence in elections. There's some question about whether the First Amendment in other circumstances would go to a perception of a bad thing, but that's where the Supreme Court has gone. I don't want to predict what it would be, because it would be a close issue, but the court wants to protect participation in the process. If there's going to be the Republican Party versus White, I guess it was, case that was mentioned, and the one last year from the New York Supreme Court, if people decide from the New York court system, if people decide that there should be elections, the Supreme Court's not going to say that there can't be elections, even for judges. It's been around since the beginning of our country, and if there are going to be elections, there are First Amendment issues having to do with what the candidates would say and what people electing the candidates. So it's not a simple issue, but I think that the court's as sensitive as it has been to the potentially corrupting effect of money in elections from representatives, it will be sensitive particularly to the potential for corruption or the appearance of corruption in the non-political branch.
It's such a rich topic, and I'm afraid we've run out of time. Please. And we're going to take